In this session, we will see about the Article of Association in Companies Act. Article of Association is defined in Section 2, subsection 5. It says the Article of Association means the Article of Association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or this act. That is, the Article of Association means the articles filed with the registrar according to the earlier law, that is Companies Act 1956 or Companies Act 2013. So the definition is not clear. What is Article of Association? It is not defining what is Article of Association. It says it is an article filed with the registrar. What is Article of Association? Article of Association is the document which contains the internal rules and regulations for the internal management of the company. Like a memorandum of association says what is the object, what is the capital, what is the registered officer name, everything is there in there. This contains only the internal rules for the management. How to conduct a meeting, what is the borrowing power, how that will be exercised the parties, who will sign the check, all these internal matters, how to conduct a meeting, how the resolutions are passed, how the proxies to be appointed, all these things, internal things. It is in the Article of Association. Article of Association has to be all contents regarding internal management, rules and regulations, bylaws. These are things are to be in a paragraph serially numbered. Schedule 1 of the Companies Act contains a model article of association. It says if you are not using your own article of association, they can adopt that for every type of company a model article of association is in Schedule 1 of the Act. Then the article of association has to be signed by the persons who sign the memorandum of association. At the time of incorporation of the company, they have to file the memorandum of association, they have to file the article of association with the registrar. All the persons who subscribe to the memorandum has to sign the articles also. Along with their name, they have to sign, and one person has to witness. The article should contain all the rules and regulations for the internal management. There are two conditions. The articles of provision should not go beyond the provisions of the Companies Act or Memorandum of Association. In case of discrepancy, the provisions in the company law will be applicable and not the Article of Association. If there is any discrepancy between memorandum and article, memorandum provisions will be the thing which will rule, and the articles should give way for the provisions of the Memorandum of Association. For example, Section 272 says every shareholder has a right to approach for a winding up of the company. Application by the shareholder for winding up of the company. An article should not have a provision that our company shareholders do not have the power to approach for winding up of the company. They cannot have the provision because it is against the provisions of the company law, Companies Act. Same way, Section 123 says dividend should be declared only out of profit. The article should not have a provision that our company will declare even in the absence of profit. It is not possible because Companies Act says dividend only from profit. Now we will see what is a memorandum of association and articles, what are the differences. Memorandum of association is a fundamental thing based on which the company is incorporated. It contains a name, it contains a registered office, it says what are the object of the company, it says how much will be the capital of the company, what is the liability of the shareholders. These are the basic things, fundamental things. It contains a memorandum of association contains the fundamental things. But the article of association, it is only the internal rules and regulations for the management. For achieving the object of the memorandum, how to manage the company, that type of rules are in Article of Association. Number 1 difference. Number 2, regarding the alteration. Alteration of memorandum is a request some authority from somebody, approval from some cases. For example, if you are changing the name, you have to get the approval from the central government. If you are changing from one registrar's jurisdiction to another company registrar's jurisdiction, you have to get a permission from the regional director. That type of approval is required in altering the memorandum of association. But article of association, no such approval is required. Next, third difference is ultra vires. Anything which ultra vires a memorandum of association is void. Any contract. Ultra vires means beyond the power. If any contract is done for doing something which is beyond the object clause, then the contract is not valid. Even ratification, by ratification, you cannot give validity to the contract. For example, there is a company where the object clause is running omnibuses. The company entered in an agreement for purchasing a taxi, 100 taxis, agreement signed, but it is ultra vires because the company object clause does not have this provision for running taxis. Even if the shareholders agree with the proposal, even if the shareholders pass a resolution ratifying that the contract is not valid, what they have to do? They have to change the object clause, then go for the agreement. But article of association, it is not like that. For example, the board of directors can borrow 50 lakh rupees by resolution. But there was an urgency, they borrowed 60 lakh rupees. The shareholders can, by in a meeting, they can ratify the borrowing by the shareholders. Next is the binding force of the article of association and memorandum of association. Section 10 says, any shareholder has to bind by the provisions of the memorandum and articles. For example, a company started with the 10% incorporated, the 10% only signed the article of association. Subsequently, somebody might have come to the company as a shareholder by purchase of shares. And that people cannot say, I have not signed the article of association, so it is not binding on me. All the shareholders should abide by the terms rules of the article of association as if they have signed the article of association. It is a binding on the shareholders. Any dues from the shareholder should be treated as a debt. It should be recovered from a dues from a debtor. For example, that shareholder has taken 100 rupee share, he has remitted only 50 rupees, then the company can proceed against the shareholder for recovery of the unpaid share capital. Their liability is limited to the extent of unpaid share capital. They can recover money from them. Now we will see how the relationship is affected. The members in their relation with the company, members have to agree that article of association is a binding on them. One case, Borland Trustee versus Steel Brothers Company Limited. Borland's Trustee versus Steel Brothers Company Limited. In this case, the article of association has a provision that in case some shareholder becomes insolvent, the company will decide the price at which the shares to be sold. It is the articles of provision. One person was insolvent, but the receiver of the insolvent person was not agreeing to that. He was telling, it is my property, I have a share, I will decide. I will not abide by the article of association. But the court held, you are a member of you are a shareholder and you have to abide by the provisions in the articles of association. So the company shareholders has to abide by the rules of the article of association. Next, regarding the company. The company should also see that what is in the article of association and they have to abide by that. In a case, Wood versus Odisha Waterworks. Wood versus Odisha Waterworks. In this case, instead of paying dividend by cash, they issued a debenture. They issued debentures instead of cash. The articles has a provision to pay dividend only, but instead they issued shares, debentures The court held it is not correct. According to the article, you have to pay by cash. Then the next question is whether the outsiders, what is the relationship? The articles will not bind the outsiders, and the outsiders cannot claim any benefit under the articles also. Brownie versus Law Trinidad. Articles was having a provision that person will be a director till 1888. But he was removed. This person went to the court claiming that as per the article of association I have to be the director up to 1888. The court held you are an outsider, you cannot claim under the articles provisions. Then who is an outsider? Whether a person shareholder or a outsider, one person may have two roles. This is a case Yeli versus Positive Government Security Life Assurance Company Limited. Yeli versus Positive Government Security Life Assurance Company Limited. Well, there was a person appointed as a solicitor. Article of Association has a provision that he should not be removed unless misconduct is proved. Only for misconduct the solicitor can be removed. What the company did, they were giving work to some other solicitor. He was not retained as a solicitor. He went to the court. This person was a shareholder also. He went to the court. Based on article of association, I have to be retained as a solicitor, but the company is not retaining me as a solicitor. The court held you have two roles, one as a shareholder, one as a solicitor. Now you have come as a solicitor. In that case, you cannot claim something under the provisions of the articles of association. Next, we will see the articles alteration. Section 14 deals with the alteration of the articles of association. Section 14. Any provision which restricts the alteration is not valid because it is a statutory right. Companies Act gives the right to alter the articles. If there is any provision in the article of association that this article cannot be altered, it is not valid. The article of association can be altered. But the alteration should not go beyond the provisions of the Memorandum of Association or Companies Act. For example, in Hudden versus Scarborough Cliff Hotel Company Limited, the company was not having a preferential shares as in the Memorandum of Association, but this article was amended to have that. It was held not valid. Sometimes the alteration may lead to breach of contract also. One case, Chidambaram Jettiar versus Krishna Iyengar. Chidambaram Jettiar versus Krishna Iyengar. In that case, the articles provides for appointment of a person as 250 rupees salary per month. Subsequently, they altered the salary as 25 rupees per month. The person went to the court claiming that according to the article of association, 250 rupees is due as salary for my services, but they are now altering. He was objecting to that. The court held they have a right to alter their article of association. You should have a separate contract for getting a 250 rupees as salary. If you have a contract, then it will lead to breach of contract. You can proceed against the company. That third party cannot restrict the company from altering it. They will alter, but what are the effects the company has to face it. If that is there is another agreement, then they have to pay damages for the breach. Even the courts may restrain the company from altering if injury is done to a third party by alteration. One case, Harichandra Deva versus Hindustan Cooperative Insurance Society Limited. This person was depositing money. They have to make a payment after some time, every month, like insurance. What the company did, the company made a change in the alteration that this amount should be paid only from the special fund. They created a special fund. When the money was due, there was no money in the special fund. The company refused to pay. He went to the court. Court held this alteration is not correct and the court restricted that alteration because it is leading to a damages, injury to a third party. Likewise, alteration cannot be done for increasing the liability of the shareholders. Shareholders' liability is limited to the extent of the unpaid amount of the share capital, limited to the extent of the face value of the shares he has purchased. The alteration, by alteration of articles, they cannot compel a person to purchase shares. The provision, new provision, all the shareholders should buy equal amount of their holding as a new shares. If they are having 100, they have to purchase another 100. If the article is saying like that because of alteration, it is not valid. The next one is the article's alteration should not result in fraud on minority shareholders. Because it is by way of, they are passing the resolution by way of majority. By altering something, they should not introduce a new rule to the disadvantage of the minority people, minority shareholders. That is not valid. Now in the next session we will see about the doctrine of indoor management in articles of association.